Here's a story that will make you question who really pays the price when climate disasters strike, and whether justice has an expiration date. A Puerto Rican federal court just slammed the door shut on what could have been a landmark climate accountability case, leaving nearly 80 devastated communities empty-handed in their fight against big oil. But here's where it gets controversial. The judge didn't even address whether these oil giants actually deceive the public about climate risks. Instead, she tossed the entire case because the communities apparently waited too long to seek justice. Let me break down what just happened, because this decision has implications that stretch far beyond Puerto Rico's shores. On Thursday, U.S. District Judge Sylvia Carreno-Call delivered what many are calling a crushing blow to climate litigation efforts. She dismissed the massive class action lawsuit that targeted some of the world's most powerful energy corporations: ExxonMobil, Chevron, Shell, BP, ConocoPhillips, Motiva, Occidental, BHP, Rio Tinto, and the influential American Petroleum Institute. These weren't random defendants. They represent the heart of the global fossil fuel industry. The municipalities claim these corporate giants engaged in a coordinated conspiracy to hide the true climate dangers of their products from the public, essentially arguing that the companies knew their fossil fuels would supercharge extreme weather events, but kept quiet about it for decades. The community's argument was both simple and devastating. They believe the human-caused climate change made Hurricanes Irma and Maria far more destructive in 2017, and that these companies should bear responsibility for the enhanced damage because they deliberately concealed climate science that could have helped communities prepare. But here's the part most people miss, and where this gets really frustrating for climate advocates. Judge Carreno-Call never ruled on whether the oil companies actually engaged in deception. She never evaluated the evidence about climate cover-ups. Instead, she dismissed the case on what lawyers call procedural grounds, essentially saying the communities filed their lawsuit too late. Under federal antitrust law, there's a strict 4-year window to file such claims. The judge determined that by September 2021, exactly 4 years after the hurricane struck, the plaintiffs should have known they suffered major harm and identified who to blame. Since they filed their lawsuit in November 2022, they missed this legal deadline by over a year. Here's where the ruling gets even more complex. The judge didn't treat all defendants equally. Claims against the major oil companies, Exxon, Chevron, Shell, BP, ConocoPhillips, and Motiva, were dismissed with prejudice, which is legal speak for don't even think about coming back with this again. However, claims against Occidental, BHP, and Rio Tinto were dismissed without prejudice, potentially allowing the communities to return with a more focused case against these specific companies. This decision represents a significant roadblock in the growing tsunami of climate litigation sweeping across American courts. Currently, more than 24 similar cases are winding their way through state and federal court systems, with judges reaching wildly different conclusions. Some courts have allowed cases to proceed, while others have dismissed them on various grounds, creating a confusing patchwork of legal precedents. What made the Puerto Rico case particularly ambitious was its direct connection between specific storm damage and alleged corporate misconduct. Rather than making broad claims about general climate harm, these communities tried to draw a straight line from corporate deception to the intensified hurricanes that devastated their island home. Naturally, industry representatives are celebrating this outcome. Ryan Myers, a senior vice president at the American Petroleum Institute, characterized the dismissed claims as meritless and criticized them as politically motivated distractions that waste taxpayer resources. His statement reflects the industry's consistent position that climate policy decisions should remain with Congress rather than being determined by what he called a patchwork of courts. Shell, one of the named defendants, chose not to comment on the ruling. But this raises some uncomfortable questions that deserve serious discussion. If communities genuinely didn't understand the full scope of climate-related corporate deception until recent years, as many climate scientists and legal experts argue, should they really be penalized for not filing lawsuits immediately after disasters strike? Is a 4-year statute of limitations reasonable when dealing with complex climate science that took decades to fully understand? And this is the part most people miss. These communities were dealing with unprecedented destruction, displacement, and recovery efforts in the immediate aftermath of the hurricanes. Should they have been expected to simultaneously investigate corporate climate deception and file federal lawsuits while they were literally rebuilding their lives? The timing issue also highlights a deeper controversy in climate litigation. Critics argue that these lawsuits are opportunistic attempts to extract money from successful companies for damages that result from complex global phenomena. Supporters counter that this represents long overdue accountability for corporations that allegedly knew about climate risks but prioritized profits over public safety. The Puerto Rico dismissal will likely influence similar pending cases across the country, though each operates under different legal frameworks and timelines. Some state courts have been more receptive to climate liability arguments, while federal courts have generally proven more skeptical. What makes this story particularly compelling is how it embodies larger questions about corporate responsibility, climate justice, and legal accountability. These Puerto Rican communities argue they were essentially victims of a decades-long information campaign that prevented them from adequately preparing for intensified climate disasters. The dismissed case suggests that even if that argument has merit, legal technicalities can still prevent communities from seeking compensation. So here's my question for you. Do you think a 4-year statute of limitations is fair when dealing with climate deception that allegedly spanned decades? Should communities devastated by extreme weather be expected to immediately identify and sue potentially responsible corporations while they're still recovering from disasters? Or do you believe these lawsuits represent an unfair attempt to blame private companies for complex global problems that require government-level solutions? This case is far from over in the broader sense. It's just one battle in a much larger war over climate accountability. But it raises fundamental questions about justice, timing, and corporate responsibility that affect every community facing increasing climate risks. What's your take? Should the legal system make it easier or harder for communities to seek climate-related compensation from major corporations?